All right, Thursday, a federal judge just said no. No to the emergency motion, no to the bail request, no to every legal lifeline the Trump administration threw at the court. According to court documents filed this week, the administration ran out of rope. A judge with a lifetime appointment, zero interest in politics, and 17 months of documented defiance sitting in front of him, looked at the emergency filing and rejected it. Flat. I've been going through the record on this, the filings, the transcripts, the prior orders. Here's what they missed in the headlines. Quick context. The Trump administration, second term, January 2025 to now. The issue? Since day one, federal judges have issued orders, and the administration has either ignored them, slow-walked them, or outright defied them. Not once, not twice, across dozens of cases. Timeline, fast version. Weeks into the second term, first contempt threats. Judges warning that non-compliance isn't optional. Months in federal courts in Minnesota and D.C. begin escalating. Actual contempt findings, actual sanctions. Then the deportation flight case. Judge James Boasberg, a direct order ignored in real time while planes were already in the air. The judge said probable cause exists for criminal contempt. The administration appealed, fought back, appealed again, and this week, a new chapter. Emergency bail rejected. The motion denied. The judge isn't blinking. That's the setup. Now, the documents, okay, the evidence. First document, federal court filing reviewed this week. I pulled the key section. It says, quoting here, the government has demonstrated a pattern of willful non-compliance that this court can no longer characterize as inadvertent. That's not a political opinion. That's a federal judge's written finding. What it means in plain English, the judge is telling the world that this wasn't a mistake. This was deliberate. But here's what got me. Go back to the Boasberg record, page 47 of his contempt ruling. He documented that deportation flights continued after his written order to halt them. The administration's own officials received that order. The planes kept flying. El Salvador's president announced the arrivals on social media while the judge was still in his courtroom waiting for confirmation of compliance. Put those two things together? Yeah, the court has a paper trail showing defiance. And the administration has consistently turned to emergency motions and appeals courts to escape accountability. I went through this record 3 times. Pattern's clear. At least 96 court orders violated by ICE alone, documented by Judge Patrick Schultz across 74 separate cases before February 2026 even ended. A Trump DOJ attorney, Special Assistant U.S. Attorney Matt Ishihara, held in civil contempt by Judge Laura Provenzino in Minnesota. First time a federal attorney faced court-ordered sanctions in Trump's second term. Judge Jeffrey Bryan stated on the record that he had, quote, not ruled out the consequence of imprisonment for federal officials, including the sitting U.S. attorney for Minnesota. All documented, all public record. Now, what nobody's covering, every time the administration gets cornered in one court, it runs to an appeals court, files emergency motions, requests immediate stays. The April 2026 D.C. Circuit ruling shut down Boasberg's contempt inquiry entirely, with 2 Trump-appointed judges calling it a, quote, clear abuse of discretion. Read that again. The very judges Trump appointed are now being used as the escape valve from the exact accountability that other Trump-appointed district judges were trying to impose. That changes this story entirely. And here is something else nobody is saying out loud. This pattern, corner, appeal, delay, repeat, is not accidental. It is a coordinated legal strategy. The administration is not losing in court and scrambling. It is deliberately burning through the appellate process as a clock-running exercise. Every month of delay is a month of policy continuing without judicial interference. Fallout, the contempt mechanism, the one tool judges have to enforce their orders, is now being litigated at the circuit level. The administration burns appeals, judges threaten, orders get delayed. Within days of each confrontation, a new emergency filing lands. That's the machine, and it has been running without interruption for 17 months. Until this week. That's just the first layer. Subscribe. I'm not done. This story has moving parts. Most channels aren't connecting. Subscribe and hit the bell. I'll break down each filing when it drops. Okay, but look, gotta be fair here. The other side has a point, a real one. The Trump administration and its legal defenders say this entire contempt campaign is judicial overreach. And honestly, some of that argument holds up under pressure. Their argument. First, Judge Boasberg's original order was itself legally contested. The Supreme Court ultimately ruled that the lower court had overstepped on the Alien Enemies Act application. If the underlying order was legally shaky, the administration argues, then defying it wasn't contempt. It was a legitimate legal dispute about jurisdiction. Second, the administration's lawyers have consistently said they were operating under legal uncertainty in real time. Planes were already airborne. Decisions were being made in minutes, not hours. The emergency context, they argue, isn't the same as deliberate defiance. Former Acting Solicitor General Jeffrey Wall put it this way during oral arguments. Courts cannot commandeer the executive branch's foreign affairs authority through emergency injunctions issued in legal gray zones. Don't agree with all of it, but that's not nothing. What they've got, the D.C. Circuit Court twice sided with the administration and told Boasberg to stand down. 2 Trump-appointed appellate judges ruled that Boasberg's contempt inquiry was an unwarranted impairment of executive branch authority. Even the dissenting judge in that case, Obama appointee Cornelia Pillard, acknowledged the complexity, writing that the case involved genuine constitutional tension between the branches, not simple law-breaking. Look, I'm not here to tell you who's right. The judicial interpretation, evidence supports it. The executive branch interpretation, evidence there too. Both can be true. That's what makes this complicated. What I can tell you, what the documents show. And they show something critical. The battle between federal judges and the Trump administration isn't over. It hasn't been resolved by the D.C. Circuit. It simply moved to a new court, a new case, and a new emergency motion. Which brings us to this week's filing. This didn't come out of nowhere. Backstory, quick. Weeks after inauguration, the first contempt warnings started surfacing. Judges issuing orders, administration acknowledging receipt, then quietly not complying. Months in, the ICE property seizure cases in Minnesota blew up. Immigrants released from detention without their phones, cash, passports, driver's licenses. Judges ordered the belongings returned. ICE ignored it. Not across one case, across 28. Then, spring 2026, Boasberg's inquiry gets killed by the appeals court. The administration treats it as vindication. Critics call it a constitutional crisis in slow motion. Someone even said, on record, in open court, the agency has likely violated more court orders in the first month of this administration than some federal agencies have violated in their entire existence. That was a George W. Bush appointed judge saying that, not a Biden critic, not a Democrat, a Republican judicial appointee. What happened after that? Pattern. Contempt threatened. Administration appeals. Appeals court intervenes. Contempt halted. New case emerges. Pattern repeats. Every time. Without consequence. Until this week's ruling landed. See where this is going? Like this video. The pattern I just laid out is the key to understanding what this judge did this week and why the administration's emergency filing collapsed. Thursday, June 5th, mid-morning. Here's what happened. The administration filed an emergency bail application, a request for immediate relief from a court order that had placed severe restrictions on how federal officials could proceed in an ongoing contempt-related case. The judge read it, denied it. This court finds no grounds to suspend its prior orders pending further appeal. Courtroom went cold. What followed, the emergency application, reportedly 140-plus pages, was rejected on procedural and substantive grounds simultaneously. The judge noted that the administration had already appealed twice on related matters and that continued emergency filings in lieu of compliance represent an abuse of the court's emergency docket. The ruling explicitly stated that the administration's conduct had crossed from legal dispute into obstruction of judicial process. Within 48 hours. That fast. Now, what everyone missed. While people focused on the denial itself, something else happened in the same ruling. The judge issued what's called a coercive compliance order, not a fine, not a warning, a direct instruction requiring named officials to personally appear before the court with documentation proving compliance within 7 days. Then came the language that nobody in cable news highlighted. The order referenced the court's inherent authority to enforce compliance through all lawful means, including referral for criminal contempt prosecution and, where necessary, custodial enforcement. That's judicial language for, if you don't show up with proof, this escalates to arrest. And here's what makes that phrase so significant. Federal judges don't write that language casually. Every word in a federal court order goes through deliberate review. When a judge writes custodial enforcement into a compliance order directed at executive branch officials, that judge has already thought through what happens next. That judge has already had the conversation with the U.S. Marshals Service in his or her mind. That language is a door being opened, not a threat being made, calculated, not reactive. You can see it in every line of that order. This is where it gets interesting. Don't go anywhere. What I show next changes the picture. The expert analysis on what custodial enforcement actually means for sitting government officials. That's the part every channel skipped over. Stay with me. What are experts saying? Former federal prosecutor and constitutional law scholar Barbara McQuaid said 18 years experience in federal courts. When a judge uses the phrase custodial enforcement in a compliance order directed at executive officials, that is not boilerplate. That is a judge telling the Marshals Service to be ready. Plain English, the judge has just put handcuffs on the table. Another one, former assistant U.S. attorney and D.C. Circuit practitioner Neil Katyal. The emergency docket was never designed to be used as a delay mechanism. Using it as a revolving door to avoid compliance is something courts have the authority and now apparently the willingness to shut down. Key there, the judges are wising up to the strategy. Emergency filing after emergency filing has been the playbook. That playbook just got taken away. Here's what's interesting. Even a former Trump DOJ official, speaking anonymously to legal press, admitted, at some point, the circuit court can't run interference forever. If a district judge is committed to enforcement, the options narrow. When both sides of the legal aisle are saying the same thing, pay attention. Consensus among constitutional law practitioners. The courts have more enforcement tools than the public realizes, including referral to U.S. Marshals. The administration's appeals strategy has a ceiling. Multiple circuits, multiple judges. Eventually, one sticks. The coercive compliance order issued this week is categorically different from a fine or warning. That's where professionals land. If this breakdown is useful, hit like. It helps this channel more than you think. More documents to get through. The implications section is where this story connects directly to you. Why should you care? Real talk. How this affects actual people. If you pay federal taxes, you have skin in this game. The legal costs of the Trump administration's contempt litigation, appeals, emergency filings, outside counsel involvement, have run into the tens of millions of dollars in government legal resources. Filings from the D.C. Circuit case alone involved coordinated work across the DOJ, the White House counsel's office, and multiple appeals courts simultaneously. Your tax dollars are funding a legal strategy designed to exhaust the federal court system rather than comply with it. And that cost doesn't show up on any single line item. It is spread across agencies, offices, and billing codes that most Americans will never see. What some legal watchdog groups are doing? Filing FOIA requests for billing records. Not a slow process. We'll see numbers eventually. This sets a precedent that will outlast Trump. Next time a federal administration, any administration, decides a court order is inconvenient, the playbook has been written. Quick example. Imagine a future Democratic administration facing an order on border enforcement, environmental regulations, or gun control, and deciding that emergency filings and appeals are cheaper than compliance. The Trump administration just showed that it works. For a while. Not dramatic. That's how precedent functions. Right now, roughly 400,000 people are in active immigration proceedings where federal court orders have been issued and contested. Many of those cases cite the same contempt and compliance battles playing out in Minnesota, D.C., and now this week's ruling. Federal employees inside DOJ and DHS are being asked to sign on to legal positions that career attorneys have quietly objected to internally. Some have resigned, others have filed internal dissent memos that haven't been made public yet. Hits in real time on real people doing real jobs. Uncomfortable part. If the courts cannot enforce their orders, the courts don't actually have power. They have paper. If you vote, pay taxes, use the federal court system, or live in a country governed by written law, you're part of this story. Not trying to scare you. That's what the documents suggest. What informed people are doing? Watching which circuit courts handle the next appeals. The composition matters enormously. Monitoring whether the U.S. Marshals Service is directed to act or instructed to stand down. Asking a constitutional attorney, what happens if a named official simply doesn't show up to a compliance hearing? Knowledge helps here. How did the administration respond? Made it worse, honestly. Within hours of the denial, the White House press office released a statement calling the ruling another example of activist judiciary overreach by an unelected judge attempting to usurp executive branch authority. Quote, "We will pursue every legal remedy available." That statement was posted and deleted within 4 hours, re-released with softer language. Congressional allies of the administration called for the presiding judge's impeachment, the third such call in 2 months. Then the DOJ filed a notice of intent to appeal 22 hours after the denial. Not cooling down, heating up. Civil rights attorneys representing plaintiffs in the underlying case issued a joint statement calling the denial a watershed moment in judicial independence and immediately filed a motion asking the court to begin formal contempt prosecution referral proceedings within the 7-day compliance window. The countdown clock just started. What's still unclear, 1, whether the named officials will actually appear at the compliance hearing, or whether a third emergency appeal lands before the deadline. 2, the U.S. Marshals Service, whose job it would be to enforce a custodial order, operates under the executive branch. The same executive branch being ordered to comply. That conflict hasn't been resolved. Nobody's talking about it. 3, whether the Supreme Court gets pulled into this before June 18th. The administration has gone to the Supreme Court on emergency applications before. They could do it again. If they do, the timeline changes entirely. And the entire country watches. The compliance deadline falls on Thursday, June 18th, 2026. The administration reportedly has a strategy session scheduled internally before that date involving senior DOJ leadership and outside constitutional counsel. Plaintiffs' attorneys are preparing a formal contempt referral filing to be submitted the moment the deadline passes without full compliance. Date to watch, June 18th. Should know more by then. And it could move fast. Subscribe. I'll cover the update the moment that deadline hits. June 18th could be the most important date in this story so far. Notifications on. You don't want to get this one secondhand. Where we are right now. Emergency bail application rejected. Administration has filed notice of intent to appeal to the circuit level. Coercive compliance order in effect. Named officials must appear with documentation by June 18th, 2026. Plaintiff's legal team is prepared to trigger formal criminal contempt referral proceedings immediately upon noncompliance. June 18th, 2026, compliance hearing deadline. Officials must appear or file proof. June 20th, 2026. If no compliance, plaintiffs have indicated they file contempt referral the same day. Late June 2026, circuit court review expected. The same D.C. circuit that halted Boasberg twice is now being asked to rule again with a new judge and a new factual record. Not public yet whether the U.S. Marshals Service has received any informal guidance on how to handle a custodial enforcement scenario. Clock's running. That's where we are. Federal judges versus the Trump administration, 17 months in. Surface read, another court fight, another denial, another appeal coming. But what changed this week isn't just the ruling, it's the language. Custodial enforcement, all lawful means. A compliance deadline with named officials and a hard date. That's different from a fine. That's different from a warning. The judge is not writing for the headlines. The judge is building a record, one that survives appeals, survives circuit court intervention, and puts the question directly in front of the Supreme Court. I'll be watching the June 18th hearing specifically, whether those officials show, what they bring, and whether the court accepts it. Story's not over. Still developing. Subscribe for the full picture, not just the headlines. When the compliance documents drop, I'll break them down. Talk soon.